Well, good evening, everybody. My name's Jane Bickerstaff, and I'm the head of crime at 9 Bedford Row. Welcome to the next in our autumn lecture series. We're really lucky to have in chambers Andrew Bousfield and Lucy Kinder, who are both former journalists before their careers took a change of direction, and for some strange reason they decided to come to the criminal bar. But Andrew was a lawyer on The Sun and the Sunday Mirror until 2011, dealing with super injunctions, big crime stories, and everything else, he tells me. I'm sure he can explain what that means. And after that, he was an investigative journalist with Private Eye, focusing on money laundering and whistleblowing stories and the NHS. Lucy was a journalist on The Telegraph until 2014, covering general news, which includes crime stories. And she also worked at the Ministry of Justice on policy. So they're both going to incorporate some of their experiences into tonight's lecture, which, as you can see, is entitled How to Handle the Media. It's an area of law that doesn't particularly get a lot of attention, how the criminal courts and the media work together and how criminal defendants are to be treated by the media. And I'm told that what we're going to get this evening is a whistle-stop tour through media law as it is relevant to criminal practitioners. So without further ado, I'm going to hand you over, I think, to Andrew, who's going to start first. Thank you, Andrew.
Well, thank you very much. Good evening. For those of you who are online, I don't intend to be very long. I should be only about 4.5 hours. There'll be no break for dinner, and there'll be a 4-hour exam coming your way tomorrow for 15 minutes of CPD points. But for those of you who are here, you will have a bespoke lecture dealing with everything. Please feel free to ask any questions. So what we're going to deal with today is the media and the history of it. It's going to be quite a lot of history. If you're bored of history, please say just turn off the history channel and move on. But there is some history. So we're going to deal with libel law, privacy law, contempt law, investigation, arrest and trial, which is the stages of criminal proceedings. So that's the table that we're going to get towards at the end, which tells you what happens at each stage of the proceedings. So there's the table, sorry you haven't seen it, that's what we're going to deal with. Investigation, arrest, charge and trial. So first of all, libel law, defamation, some of you may have heard of it, some of you may not. It's a Victorian headache, and particularly I think 243 young aristocrats died in duels, and France had created courts of honour so that disputes could be resolved in courts. And you'll hear, there's a bit of history here. There was a problem with serving soldiers, having duels, etc. So the law of libel was created to prevent people killing themselves so they could resolve their disputes in court. And you're entitled in libel law to two very rare presumptions which don't exist in the civil law. You're entitled to the presumption of damage and the presumption of falsity. So anyone who says anything libelous about you, it's presumed to damage you and it's presumed to be false. So all you have to do is turn up at the court and the burden shifts. Very unusual in the civil law landscape. And this is why the UK is very attractive to libel tourists from all over the world, because we have the most liberal libel law, which is a Victorian anachronism. Even America, in fact, requires you to prove that the allegations printed about you are false. Changed by the Defamation Act 2013, where there's now a requirement to prove some form of harm. I don't know if that's really working. Privacy law, right. So very quickly in 5 minutes, what's privacy? England was a Protestant country. The Protestant, there's Oliver Cromwell with all of his warts. I like that picture of him because of the warts. I think he had bipolar. Does he look like a happy bloke? I don't know. But he was the guy who tore the churches down, ornaments removed, and you'll remember that the Protestant Revolution was about an individual relationship with the Lord, with God. So what did the Protestants do? We're going to go through this very quickly. Well, they tore down churches. So here's an example of William Dowsing. He went to St. Peter on the Chapel. They smashed 100 cherubim and angels, and they tore out the passages in the Bible that were written in gold letters. So a public order case from a long time ago, pulling down statues, etc. That was the Protestant faith. So privacy law never developed in English law. We never had a concept of privacy in England. There was an equitable action for breach of confidence, but that covered confidential information, often business related, and didn't cover private or intimate information. So now I'm going to move on to the English versus the continental versions of privacy. And just to illustrate that to you, we've got a cooked breakfast and a stylish man eating a croissant in France, drinking an espresso. So they're the two systems that we're looking at. So in England, remember that we had a press that was red in tooth and claw. So you will know this, it doesn't happen so much anymore, that tearing down false idols. So anybody, politician, public figure who has engaged in hypocrisy, it could be splashed all over the media. America has a very limited right to privacy, which is more focused on commercial image rights. So UK and America, you put in the kind of Protestant sphere. And then when you move to the continent, you have possibly a more Catholic view of it. So in France, there's always been a right to privacy since the French Revolution, and that is to stop the overbearing power of the state. It's a criminal offence to breach privacy in France, and if you ever read French papers, it's like reading dry porridge. It's boring, and it tends to focus on political disputes, and they have a political establishment which is run by graduates of the Grande École de Venise. So that's the French version of privacy, a right to privacy, but not a particularly vibrant media landscape. Germany also had a right to privacy put in place after World War II, obviously because the branding of Jewish people, etc. It was felt that there needed to be a right to privacy to protect people's personal information. Constitutional court's been very active in Germany since World War II. They have a limited tabloid press, and criminal defendants have their name and image protected in Germany. So here's an example from Maddie. What happens in Germany is even the most beastly killers get referred to like Blue Peter presenters, so they get referred to as John S. or something like that. And you read these things in a paper about vile crimes, and they're protected. So here's the example, the Maddie suspect, English press unable to name him, other than, I think, Christian B. So the sex scandal, I told you this is a whistle-stop tour. I'll try and get through it as quickly as possible. Sex scandal in English newspapers now, sadly, a thing of the past, but here's some examples. Ryan Giggs and the sister-in-law, John Terry and the girl next door, David Beckham and the senorita, Jude Law and the nanny, Wade Rooney and the granny, Jeffrey Archer and the prostitute, Max Mosley and the prostitutes, Dave Mellor and the Chelsea top, Brooks Newmark and the Paisley bottom, Ron Davis and the badger. So there you go, Protestant newspaper culture at its best. And here's some examples. I think these would probably be criminal offences in the UK, but this is in Uganda, where they also have a red top culture. So they are attempting to create sun-like newspapers in Uganda. I'm not even going to read out what it says there. You can read it yourself. But there you go. So that's Protestant culture exported to Africa. The French concept of privacy, 1996, President Mitterrand dies. What nobody knew in France, because it had never been published in the newspapers, was that he had, I was going to say a mistress for every day of the week, but I don't think that's true. I think he just had one mistress with a family. And this was published, and the shocking pictures published after he died of his second family, which the press had never seen fit to publish because of the right to privacy in France. So then we move on to 1998, Tony Blair's government, and the right to privacy is brought in the UK. Worried that it would lead to the type of continental breakfast and the type of privacy culture that would destroy the UK, the Human Rights Act Section 12 contains this section, which I put in bold, which tried to create some type of priority for freedom of expression. It hasn't worked. because of course once you've imported the human rights, European Convention on Human Rights, those rights are simply balanced against each other. So this leads to 2016 PJS against the Sun on Sunday. The claimant was married to YMA, a well-known individual. They've got young children, and he met A and B with whom he had sexual encounters. AB had a partner, CD, and by a text message, the claimant asked CD if he and AB, his wife, were up for a three-way sexual encounter. After which the sexual relationship between PJS and AB came to an end, though they remained friends. So any public interest in that? Well, at first instance, it was found that Judge Cranston, claimant and his partner portraying an image to the world of a committed relationship, accepted that commitment may not entail monogamy, but concluded that there was a public interest in the Sun on Sunday correcting the image by disclosing the fact that the claimant engaged in casual sexual relationships. So, i.e., it's fine for the Sun to publish, but that was overturned on appeal, where it says once that it was accepted that commitment may not entail monogamy, there was no false image to require correction, and therefore no right to publish it. Supreme Court agreed. Criticism of conduct cannot be a pretext for invasion of privacy by disclosure of alleged sexual infidelity. You can read the rest for yourself, but effectively they relied on the European Convention of Human Rights that said there was a fundamental difference between tawdry allegations and debates capable of contributing to the public interest in a democratic society. So that was the end of the sex scandal in the UK. And there you go, 2016, the Sun newspaper, the day free speech drowned in a paddling pool of olive oil. So there we go, requiem for the tabloid press. That was the end there. 2022, you'll remember all the political debate about a British Bill of Rights. That would have given precedence to the right to freedom of expression, which it was hoped would have remedied this for the UK press and enabled them to publish what they had always published. So we now move on to criminal law. Questions for you to ask yourself. What is privacy? So privacy is the right for an individual to develop. It includes the most sensitive areas of life, such as sexual expression, medical information, things like that. The Germans have various spheres of privacy. They've made, of course, the Germans have made a system of it, and they have circles of different privacy coming out from the individual. So privacy law is really the freedom to develop your own autonomy. What's the difference between privacy law and reputation? Well, it's often very little, as in they merge into each other. Why do people keep bringing privacy actions? Well, the phrase publish and be damned, you can't get an injunction in libel law, but you can get one in privacy law. So that's why claimants are now interested in bringing in privacy actions. Previously, you couldn't stop the press, as in you could complain, you could say what you wanted, but the press would publish. Now you can get an injunction to stop the press publishing, provided you've got some form of privacy interest. So the Leveson inquiry, it was actually an inquiry into the press, but ended up being an inquiry partly really into the police. And Brian Leveson said in 2012 that he thought that the names of identifying details of those who are arrested or suspected should not be released to the press or the public. So this was a big change for the UK tabloid, which had a UK tabloid market, which had a diet of criminal stories. Suddenly it's Brian Leveson saying that police shouldn't be talking to the newspapers. College of Policing guidance, effectively when police had talked to journalists before openly, suddenly guidance preventing that. Then we move on to Jimmy Savile, because Jimmy Savile is responsible for the record deck, for mixing music together. He always claimed he invented that. But it's with Jimmy Savile that we start to see the big changes in privacy law and criminal law. So he dies 2011. Suddenly there is UK hand-wringing about why he hadn't been exposed before after he died, and Operation Yewtree begins in 2012. So in terms of convictions, you might remember these, but it's not a pub quiz, but here we go. What did he get? Anyone remember? Stuart Hall. So he got 15 months increased to 30 months. Rolf Harris, anyone remember what he got? 5 years, 9 months, 12 indecent assaults, 4 victims. And Timmy the Weatherman, surprising, 5 years, boys at schools. So there we go. So they're the successful U-Tree convictions, but where it starts to change in the media landscape is the NFAs. So here we have Jim Davidson, NFA'd, and wrote a book about it afterwards, criticising the police. And then we have Paul Gambaccini. Anyone associated faith? No name. Here we go. Paul Gambaccini. He got 250,000 from the Met as a result of fake sex abuse claims. So he also wrote a book about it. Finally, Cliff Richard. He was NFA'd in 2016, and he was awarded £400,000 damages from South Yorkshire Police, who allowed a BBC helicopter to film the warrant executed at his address. So the landscape was changing for those who had been wrongly accused. Operation Midland, this was another big police failure, 2014-16. So Carl Beach, you might remember him, he was an NHS manager, not doing much for the reputation of NHS managers if they had one, who had made a vast panoply of false allegations about high-level politicians abusing him. So the Met announced their investigation in 2014 into claims that he'd originally published on a blog, a journalist had seen, and the Met started an investigation. So this was the time of great interest in historic sexual offences. Harvey Proctor accused, he was searched, he was NFA'd, and he was reported to have received £900,000 from the Met in settlement. Lord Bramall, in March 2015, searched, interviewed, you might have seen the footage on the news of a very old man in interview, reported that the Metropolitan Police had paid substantial compensation for the searches that were unjustified. So that led to the Henriquez report, which I won't read out, but effectively, retired judge from the north of England said that celebrities will be subjected to false allegations, bandwagoners, those of poor mental health, I think he says. So this was really saying that we need to be more careful about those accused of criminal offences. Operation Midland, just so you remember, it ended in July 2019 with Carl Beach getting 18 years, 12 counts of perverting the course of justice, and 1 of fraud. The prosecution said he was a manipulative, prolific, deceitful liar. Lord Bramall, Daily Mail ran a campaign, the hero who died without justice. He died at 95, and they called Scotland Yard's disgraceful inquiry a fantasist, nearly ruined the reputation of the former head of the armed forces. So you can see the tide was turning against the historic sexual offences movement. And then Richard Henriquez, if you get time to read this book, in 2019 when retired, he wrote a book saying why hadn't anything been done about his report in 2016. He called it a grossly incompetent investigation, misleading of a district judge by the NPS to get the warrant. It talks about the compensation. He read the books. In a nutshell, Nick had alleged that between the ages of 7 and 16, on numerous occasions, he'd been collected by a car from his schools in Wiltshire, Oxfordshire, Surrey, where he and other young boys were angrily raped, burned, stabbed and tortured by a circle of abusers including Edward Heath, Lord Britton, Lord Bramall, Sir Maurice Oldfield, former director of MI5, etc., etc. So that was the nature of his allegations. And I remain firmly of the view that one or more of the officers have either perverted the course of justice and or committed misconduct in public office in the obtaining of the search warrant. So he's not mincing his words in this book he's written. The 2 most senior officers were never investigated. The process was unreasonably protracted. Harvey Proctor was again interviewed and shown a penknife proposition was put to him that he cut Nick's genitals with a knife, and Edward Heath had intervened to say no. Mr. Proctor told the officers the fantasy gets bigger by the minute. He told them they'd been taken for a ride. So you can see the strength of feeling about this historic sexual movement, and this is where the privacy comes from. Cliff Richard, he sued both the BBC and South Yorkshire Police, and
You need to unlock your iPhone first.
and he won damages. Now, what that case finds is that you do have a right to privacy when you are suspected of a crime. So it seems to me, as a general principle, a suspect has a right to privacy in relation to a police investigation. So this is entirely new in English law, 2018. And here's a bit I think I do disagree with Mr. Justice Mann. The question is, did the BBC have a right to publish the arrest of the helicopter footage over Cliff Richard's house? And it said, well, there's a right to a general debate because of, you can see here, several were convicted. Rolf Harris, Stuart Hall, Max Clifford, Gary Glitter was investigated and charged by the time of the events. Others were charged but acquitted. Rochdale and Rotherham is mentioned. The whole thing was very much a source of legitimate public interest and concern. The public had a legitimate interest in knowing that the police were pursuing alleged perpetrators. However, the court said, in terms of identifying the perpetrators, it does not follow that because of a general level of public interest, you can identify the subjects of the investigation. Knowing Sir Cliff was under investigation might be of interest to gossip mongers, but it does not contribute materially to the genuine public interest in the existence of police investigations in this area. To me, I think that's I think it's almost illogical. I don't think you can have a debate about snow without talking about snowmen. And I don't think you can have a general debate about sexual abuse without specific examples of it. So it just fundamentally misunderstands how the media works. And I think you then get more towards a French view of the concept of media, which I've referred to as dry porridge. So that, anyway, that's the finding of Mr. Justice Mann. And then we get to the final authority, which is ZXC in Bloomberg 2022, and this was to do with a letter of request in relation to a British businessman, and Bloomberg had got hold of the letter of request, the journalist had got it. It's a publicly traded company, and it was still, the UK authorities were still investigating. There had been some interviews with some witnesses and suspects, but there hadn't been any warrants executed or searches. And it was to do with corruption, bribery, offences under POCA, and fraud. So you might think quite an interesting story to Bloomberg, which is a financial news outfit. And the question was whether they could name this businessman who was suspected of these crimes, and there was a letter of request sent out to a foreign agency, which Bloomberg had obtained. And it was found that at the investigation stage, the publication of information that a person is under criminal investigation will damage the reputation together with other damage, irrespective of the presumption of interest. This has led to a general rule or legitimate starting point that such information is generally characterised as private, different from, of course, charge trial. Once you're charged or on trial, then open justice applies. So this is the big change in English law, that somebody who's suspected has a right to privacy and the media can't publish it. Response from Bloomberg, it was pretty tough. Let's be clear about what privacy, this is the editor-in-chief of Bloomberg, let's be clear about what privacy means in this case. This was not a story about what most of us might see as ZXC's private life, a picture of his children, his health details, his romantic history. This was reporting on his business activities and investigation by the authorities into possible malfeasance at a huge company that could have an effect on many people who investigated it. It gets worse. If you can't report about potential wrongdoing before any charge is brought, then once somebody is charged, and ZXC has not, all the proceedings become sub judice with potential reporting restrictions added. Somewhere, Robert Maxwell is smiling. So that was Bloomberg, and this is, as you can see, is an area of huge debate. So that is the law of privacy as it applies to criminal defendants. I'm just going to hand over now to Lucy for the bit on contempt.
Thank you, Andrew, for the introduction. I've somewhat drawn the short straw of taking you through contempt and reporting restrictions, I think, in about 15 minutes. And I say short straw because it is a particularly frustrating, confusing area of law, contempt, because it involves interplay between civil and criminal law. Starting briefly with civil contempt, which has got nothing to do with which court the conduct occurs in, but it's the nature of the conduct that's important, which is, you can see on the slide there. Civil contempt generally involves failure to comply with a court order. So, for example, a restraint order under POCA. But civil and criminal contempt can be punished with custody, and the appropriate standard of proof for civil contempt is the criminal standard, which means that all contempt proceedings, including civil contempt, are criminal proceedings for the purposes of LASPO. The procedure, I won't take you through the procedure for the criminal courts dealing with civil contempt, but it's governed by the criminal procedure rules. Criminal contempt involves conduct which goes beyond that and amounts to a serious interference with the administration of justice. It's partly legislated by statute, partly by common law. The first category of criminal contempt is contempt in the face of the court, which is somewhat confusing because it doesn't have to be in the actual courtroom. But this slide shows quite a good example of what would amount to contempt in the face of the court. There's no concrete definition of what amounts to contempt in the face of the court. It's governed by the common law, but it's essentially any act or omission which creates a real risk of prejudice to the administration of justice. Any conduct that's in defiance of the court, disrespects the court, challenges the authority of the court. Aside from this conduct, another example of conduct which amounts to the face of the court: wolf whistling, wearing no clothes, wearing offensive clothes, the list goes on. This is another example of a case, 2016 case, where two men took photos during the sentencing of their friend for murder. They then posted them on Facebook, along with the comments, derogatory comments about the judge that you can see on the slide. The court held that those publications on Facebook would be akin to a contempt in the face of the court and would be dealt with the same procedure, the summary procedure. It couldn't be publication contempt, which I'll come through to, because proceedings at that point, they were published after sentence, proceedings would no longer be active. It's sufficient that the act is deliberate to amount to the mens rea. That's all that has to be proved. Coming on to contempt by publication. The main law of contempt related to publication is known as strict liability contempt, and it's governed by the Contempt of Court Act. It's a contempt to publish any matter which creates a substantial risk of serious prejudice or impediment to the course of justice. It's irrespective of intention, it's strict liability. And publication is forbidden when the case is active. And the case is active either from when a suspect is arrested or from when the warrant is issued for arrest, whichever one happens first. Criminal cases either stop being active at the point of sentence or when another factor or another decision ends the case. So, for example, the prosecution offers no evidence. If an arrest warrant is issued but no one's arrested, the active period ends a year after the issue of the warrant. Again, you'll sense a trend here. There's no set rules about what can and can't be published once the case is active. It's very fact-specific. Risk is judged at the time of publication. But broadly, prejudice means something that might make the judge or the jury biased, and impediment creates an obstruction to justice, which brings me neatly onto this case. You might remember who this man is, Chris Jeffries. This was a case where he was arrested for the murder of Joanna Yates. He was questioned, but he had nothing to do with it. And several newspapers insinuated various things about him. The passages from the judgment that's on the slides. The court held that the newspapers were in contempt for vilifying him, and the publication amounted to contempt because it risked witnesses for the defence not coming forward because of the vilification of Mr. Jeffreys. Now I'll just jump back to the previous slide because there is a much rarer case where publications can be held in contempt at common law when proceedings aren't active. Potentially when proceedings aren't even imminent. However, there has to be a mens rea. There has to be a specific intent to interfere with the administration of justice in those proceedings. An example of this was 1988, years ago. There was a family, an 8-year-old girl, and the family alleged that a doctor had raped her. It was held there was insufficient evidence to bring a prosecution, and the Sun ran a campaign referring to the alleged rapes, encouraging prosecution of the doctor, and even the editor arranged for financial help to fund the private prosecution, and the doctor was subsequently acquitted of the offence. The newspaper, The Sun, was held to be in contempt because there was an intention to prejudice the trial, but it was held, interestingly, that there would be a contempt even if the conduct related to proceedings that were pending or were imminent. There's subsequently been some doubts about whether that still holds, especially given that it could be seen as a threat to investigative journalism. But that is the law at the moment. Now, in recent news relating to Russell Brand, the Attorney General, who's pictured there, has put out an advisory which urges caution on what the media should be publishing around Russell Brand. She's being criticised because the proceedings aren't active yet. And although, as I've explained, it's technically possible for media publications to be in contempt, it'd be a very high threshold for them to be in contempt, given that proceedings are not active nor are even imminent. Coming now then to jurisdiction and procedure, civil contempt, it's usually the aggrieved party that brings proceedings, and that party can waive the contempt. For criminal contempt in the face of the court, it can be prosecuted either by the Attorney General or the court acting on its own motion. Be prosecuted both in the Crown Court and in the Magistrates' Court. For publication contempt, the courts have held that the appropriate approach is for that to be heard by way of committal proceedings to the High Court. And these are governed not by the criminal procedure rules but by the civil procedure rules. And although they are, as I've explained, still criminal proceedings. It's very small writing, but I'm not going to take you through all of it, but the summary procedure is set out in the criminal procedure rules, and this is the procedure that the court uses generally to deal with contempt in the face of the court. What happens at the court, if the court is applying that procedure? The court must explain the conduct and their powers to deal with that conduct to the respondent, who then is asked to explain the conduct, apologise for the conduct, and the court can then take no further action. The court might decide to take further action, and they can do it in one of two ways. They can either hold an inquiry there and then into the conduct, or they can postpone that inquiry. If it's in the Magistrates' Court, they have to hear that inquiry on the same day, but in the Crown Court they can postpone it to a later date. The normal rules of evidence apply, hearsay evidence, but generally, given that it's an immediate process, the summary process will be justified when there is a need for the court to act decisively, to show that its authority has been undermined, and to demonstrate that the behaviour of the such that I've discussed is not tolerated and dealt with quickly. And in the absence of that urgency, the matter should be referred to the Attorney General to be dealt with in the High Court. And the reason that the Tommy Robinson is on the screen, which you may remember. It was a well-known case in 2019. He was known as Stephen Yaxley Lennon. He was found in contempt of court because he live-streamed a video outside Leeds Crown Court, contained content of breach reporting restrictions, and he also approached defendants and told his followers to harass the defendants who were on trial. He was found in contempt in 3 different respects. The case was initially dealt with at the Crown Court using the summary procedure, but the High Court held that wasn't appropriate, and it should have been held in the High Court because the summary procedure is really only for relatively simple cases, not for those cases that require resolution of substantial factual issues. However, even though that was the case, the High Court still found him of contempt, even though there had been a breach of the procedure. Just going back to this slide, the maximum punishment, the maximum penalty for all types of contempt, including civil contempt, is 2 years in prison or an unlimited fine, except for the magistrate's court. The exceptions apply in the magistrate court. In terms of appeal, the right of appeal from the Crown Court to the Court of Appeal, or by judicial review from the magistrate's court. Moving on to reporting restrictions, there are both automatic and discretionary reporting restrictions that can be applied. Running through the more common automatic restrictions, for example, complainants in sexual and modern slavery offences, they're given lifetime anonymity unless they consent. Less common, perhaps, reported pre-trial hearings in the Crown Court generally can't be published until the trial is over. Reports of preparatory hearings in the Crown Court, long or complex cases, complex fraud cases, and unsuccessful dismissal applications, they're also generally prohibited from being reported on until the case is over. In the youth court, the media is prohibited automatically from publishing the name, address, school, anything that identifies the child or the young person involved in the youth court proceedings, whether that is a complainant, a witness or defendant. However, it's not automatic in the Crown Court, it's discretionary. And that takes me on neatly to discretionary reporting restrictions. The procedures for making a discretionary reporting restriction and considering that application in the criminal procedure rules, the courts are required to hear the media's representations in relation to a proposed reporting restrictions before they can make any order. The Crown Court several examples of discretionary reporting restrictions. For example, the Crown Court can grant anonymity to defendants under the age of 18. They can grant lifelong anonymity to witnesses under the age of 18. But there's no statutory, these are both in statute, there's no statutory provision that allows courts to order lifelong anonymity for a defendant, whether an adult or a child. However, the High Court held there is an exceptional power which is derived from the Human Rights Act and the Senior Courts Act, and this power is more commonly known about because it was used to protect the identities of John Venables and Robert Thompson. Another discretionary reporting restriction that has received publicity recently is what's called a Section 46 order, and it gives the court the power to restrict reporting about certain adult witnesses other than the defendant in proceedings. But in order to do that, the court must be satisfied that the quality of the evidence would be diminished due to fear or distress in connection with them being identified. And that has to be balanced against the public interest in not imposing a substantial restriction. And this was relevant in the case of Lucy Letby because all the babies in the case, all the families in the case were anonymised, as were 8 of the medical staff who gave evidence at trial. Anonymity is not normally given to the deceased, but if the babies had not been anonymous, then the families would be identified. The media, interestingly, the media fully accepted the application to anonymise the families. They didn't contest it. They did contest the anonymity for the medical staff who gave evidence. They argued that that would conflict with the principle of open justice. However, the trial judge was satisfied that the quality of the witness' evidence would be diminished by reason of fear of distress if they were identified. Briefly, there are some other blanket restrictions that the court can impose. They can postpone the reporting of proceedings in part or in whole for such period as the court is necessary. But again, it's a high threshold. The court must hear how reporting the trial contemporaneously would cause a substantial risk of prejudice, and why a postponement order is necessary to avoid that risk of prejudice. There is a blanket order, complete blanket order, it's called a Section 11 order, another also under the Contempt of Court Act, which allows prohibition of publication forever, which is obviously incredibly rare circumstances, intended for cases of national security, essentially limited just to that. Breach of a reporting restriction, generally the breaches of reporting restrictions amount to criminal offences in their own right. Generally, there's a defence of what's called innocent publication. If the publisher didn't know or didn't suspect that there were reporting restrictions in place. However, they can also amount to contempt if, generally speaking, it's preferred that the criminal offences in statute are charged, but it may be that it is felt that the matters of the breaches are so serious that they should be charged as a contempt. That's the whistle-stop tour of contempt and reporting restrictions, and it concludes this part of the talk. I'll hand over to Andrew now.
Well, so I said we get to the bit I hope you can learn from. So at all stages of the investigation, arrest, and then public trial, charge and trial. So what happens at those stages? Investigation, or libel law applies, so they can still sue in libel. Investigation is covered by ZXC and Bloomberg, so right to privacy now. So what can the media publish? It appears not very much. And contempt law, well, that's common law. So if the media publish something that prejudices the trial, the Attorney General would have to prove that the media had mens rea or intent to prejudice the trial, and that the Attorney General is not really ever going to be in a position to prove intent. It would be a rare case. So after arrest, if the defendant's arrested, libel law, obviously you could still bring a libel action. The fact he's been arrested, is that a neutral action? Clearly not. Privacy law, again, ZXC and Bloomberg, you're entitled to a right of privacy now if you're arrested. Maybe good reasons for that, of course, because of all the cases I went through with celebrities falsely accused of sexual crimes, historic sex offences. That's really where I think this right to privacy and arrest has come from. And Contempt of Court Act 1981 applies. So once somebody's been arrested, proceedings are active. So the Attorney General could, in theory, sue the newspaper if he could prove a substantial risk of serious prejudice. Normally that is against the defendant, i.e. saying someone's guilty when they haven't at their trial. Charge and trial, there we go. In terms of defamation, media are entitled to report trials as long as it's a fair and accurate report. It's privileged. Privacy law, no reasonable expectation of privacy once it's in an open court. Contempt law, well, reporting restrictions, which Lucy's just dealt with. So that's the criminal process in terms of media law, and now it will be any questions that you have.
Am I allowed 2 questions?
You're allowed to.
Okay, thank you. Firstly, is there a sort of generally accepted legal definition of what's in the public interest? And secondly, thinking about Cliff Richard, the justification that the police used was that if members of the public or would-be accusers saw that other accusers had come forward, it might encourage them to, and I know that was several. So there's a tension between the two, I guess.
Yes, there is. So the question is about other people coming forward and public interest. There's no definition of the public interest. So going back to Article 8, You'll remember from human rights law, let me just find the correct slide. Here we go. The Human Rights Act, and then Article 8 is here. There is a right to privacy, but then it's balanced by, there should be no, except accordance with law, public safety, protection of health and morals, etc., protection of rights of freedom to other. We all know what this is, it's a balancing exercise. So you balance Article 8 with Article 10. So in terms of privacy, the press have a countervailing Article 10 right. And what should happen is those two should be balanced. In terms of the definition of public interest for the press, no, there's no definition, and that's part of the problem, I think, that the courts have ended up getting into a balancing exercise, and there's no real principles, there's certainly no statute law. This is, in reality, judge-made law, which is the criticism of it. You import human rights law, which is simply that, and then everything else is in reality judge-made, although they import decisions of the European Court, etc. And then the question is, this was always the justification, was that if you publish the name of Cliff Richard, you're going to get other people to come forward, and the police were, journalists would say, complicit in that, and they would seek publicity because it would help their investigation. And I think there was always an argument for that, in that it's clearly what they didn't do with Jimmy Savile. So then there was a drive to name people and see if other accusers came forward. Obviously, when Jimmy Savile died, egg on the face of various people. And then that seems to have disappeared, really, with that justification for the police publishing names of arrestees to try and bring people forward. The College of Policing guidance is not to release those names now. It still goes on. I think they often confirm name and address, and the media can work it out from there, but it's not like it used to be, with the close relation between police and journalists. That's a thing of the past. Okay, any other questions? Is there any on the chat?
I have
None.
a third, if I'm allowed a third. So there was a case with the Silk, who was snogging someone outside Waterloo Station, and then to not have her name published,
Yes.
the anonymity under
Sexual offences.
Exactly.
Yes.
Has that been resolved?
Well, so this is another area, isn't it? You get lifelong anonymity if you're the accuser in a sexual offence, but if you're the accused, you're not entitled to anything. There's been various proposals, 2010, 2015, the Ministry of Justice have done consultations on whether rape accused or sexual offences accused should be entitled to anonymity. And it doesn't seem to have been moved any further in terms of statute. So by statute, you don't have a right to anonymity in rape cases, but really I think it's been resolved by ZXC and Bloomberg. So if you are accused of rape, I don't think the media can publish that. I mean, every case is different. You have to balance Article 8 and Article 10. But effectively, we are now living in a democracy where privacy has taken a much greater role in public life. There we go.
But how would you prove public interest? If you do an investigation, get enough evidence, you're not a police authority, so you don't have procedural rules. How do you give that to someone saying we think this is enough for public interest? How do you go to court and say, look, it absolutely?
Well, I mean, I think you do it in the way you normally do. You can prove public interest in terms of the effect of investigation, money laundering, what's the effect, who's harmed. It's difficult with victimless crimes, isn't it? What's the public interest with victimless crimes like that? But whether the law gives enough weight to that public interest over the obvious rights of individuals is a question. And I don't think the Supreme Court or the courts in this country have yet found a way of balancing it properly and taking into account the public interest. It needs to be properly argued before the court, I think. So yeah, it can be difficult to prove, especially when you're putting together pieces, jigsaw, various bits together, which might create a picture, but you haven't got a full picture. So
how did the Russell Brand thing sit then?
So I know Lucy talked about that. We don't know, of course, now because the police won't confirm when they've arrested people or not. So I don't know what presumably nothing. I think Lucy's probably right. Nothing's happened. But in terms of Russell Brand, the public interest in publishing it, or the media have just taken the view that they can satisfy the public interest and they've gone for it. So I guess it depends on what happens later. If he, you know, if we see the same as what happened with Operation U-Tree, then possibly you might have a liable action later on. I don't know.
That was going to be my question. What do you think Russell Brand makes of the laws of privacy, bearing in mind what you just said?
Well, they haven't been very effective for him so far.
And we know he's been interviewed as well, according to press reports.
Oh right, okay. He's voluntarily interviewed. I think I've read that. I mean, he hasn't had any privacy so far. I mean, the question with him is how much he's put in the public domain. A lot of what the press reported was simply what his radio show, what he'd had in the public domain. He can't really complain about that. Can he complain about the allegations of sexual misconduct? Yes, he could, because they would be private. We'll just have to see what happens.
So when you were a lawyer at whichever publication you were a lawyer at, how would you have dealt with that? Publish and be damned, or?
So you can't publish and be damned for privacy, that's the problem. So you have to take into account privacy rights and balance them with Article 10 rights for every article you publish. So I think I probably would have balanced it, and they've published it. What you see a lot now, don't you, is media publishing together. So with Russell Brand, I think you saw Dispatches and Sunday Times, they group together, which helps them with their public interest argument, and they've interviewed lots of people. And I suppose the argument is that the number of allegations makes it more likely that they're true or not.
These days, aren't the best intentions of the courts and the press in any event just sort of overwhelmed by the tsunami of speculation on social media? Like, for example, when they started reporting, they never named Philip Schofield, but there was so much speculation on social media, and therefore other celebrities felt the need to come out and say, well, it's not me. I'd just like to point out this person is not me.
Yeah.
That in the end, he ended up having to name himself, I think, if I remember correctly.
Well, this goes back to super injunctions, doesn't it? So, I mean, this is to do with whether the court injunctions have power, teeth, and are respected, in that you can get a privacy injunction, but you can't stop a website in America popping up and publishing a name. So initially, when the law of privacy came in, if a name had been released, breach of confidence, you lost confidence against the world once that name was out there. But they've changed the law now so that you're still entitled to privacy even when people know the name. So every publication causes more damage. But yeah, I mean, the law really applies against the mass media. Does it apply against Twitter? Not really. I mean, Twitter will respect injunctions when, I think if you go to Twitter with an injunction, they're like to respect it. But are you going to be able to take down 100 accounts which give birth to another 100, another 100 there?
Time it's come up for me has been when the Guardian in this case, misstepped and were ordered by the judge to come to court, and they sent extremely fancy counsel with very expensive suits and rocked up in the middle of a criminal trial with us all looking like we're wearing rags. So the point here, though, was what, in those circumstances, they've misstepped, the judge says, they've overstepped their bounds of the order he made. What is it they should have done, would have known, clearly would have been clear to them? I mean, the order is made by the court. Does it then go to some central body and is disseminated?
You're talking about reporting restriction?
Yeah, reporting restriction or section 4.
Section 4.
Yeah, so postponed until after the trial and they've reported anyway.
Postponement order. It's normally it's sellotaped on the outside of court. If you're a young hack and you're there, I mean, I've got some sympathy for them. They might have missed it.
Well, it's up to the judge could deal with it as contempt. they were similar.
Yeah, he dragged it in with
He
expensive
did.
lawyers.
And they did, and what they potentially do, I mean, presumably did they deal with it, because they can deal with it with that summary procedure where they say, if you apologise, is that what happened?
And the question I have though is, yeah,
Yeah.
sellotaped on the outside of the door.
Yeah,
In the
exactly.
digital age, surely there must be some centralised system.
Well, I think there is a centralised system. I think they are reporting restrictions are published. I think that some of the agencies get them. But yes, I mean, a journalist should be properly trained in court reporting, so should look for any restrictions, should ask the usher, should speak to the court clerk, speak to the court office. But you've got to have some sympathy for a young journalist who walks
Go
in
through
and
a
makes
CP.
Well, there is case law though, I haven't got it off my head, but that says that they should be informed and they should know and say, oh, I didn't suspect that there was. It's not a defence. So unless it was particularly unusual.
They had some fancy lawyers. They
Yeah.
got them in. That's how they got around it.
How do you deal with cross-jurisdictional issues? So, for example, and social media, there's two things there. So, let's say something happens in the UK courts, there's an issue and there's been some kind of injunction, so can't publish in the UK. What if, a mate of your mate publishes in the US in a media publication? And secondly, how do you deal with someone publishing something on social media which is not countable? Could be necessarily anonymous, and there's the right of the individual to say what they like. And that being used in the media as well, and possibly across jurisdictions.
I mean, so the first one, you can get a contra mundum injunction, but effectively, you can only really control what's published within your jurisdiction. So if you go to Twitter, they'll only do things in the UK. So yes, it can still be published abroad, but it won't be accessible here. So that's what privacy claimants do. What was the second question?
It's about the use of social media. So,
Well, proving dummy accounts and who owns them is an IP question, isn't it? So that's the investigation, is to, puppet accounts, sock puppet accounts.
but
It's just a factual issue.
But is the media then barred from using social media information from other jurisdictions because they're just reporting what they've seen?
Yes, so you're not, basic law of libel is that the repetition rule, so you can't, if you publish it, there's no defence for saying somebody else wrote it, you're liable for what you write. So you can't, but they do that all the time. Yeah. So, there we go, I think that's it. Shall we prepare for drinks, please?